Welcome to another episode on the Law Report. Today, I would like to talk to you about a very important legal principle. This principle being the presumption of innocence. Now, disclaimer, this is not legal advice, and nothing that I say in this video should be construed as legal advice. For legal advice, please seek the services of a competent attorney. The presumption of innocence is a legal principle that every person accused of a crime is considered innocent until proven guilty. I have not seen in the United States Constitution where the presumption of innocence is guaranteed. However, statute and court decisions such as the U.S. Supreme Court case of Taylor and Kentucky that was decided in 1978 have recognized the presumption of innocence as one of the most basic requirements of a fair trial. In the United Kingdom, the presumption of innocence has been recognized since the early 19th century. In the case of Wilmington versus Director of Public Prosecutions, 1935. The House of Lords held then that the principle of the presumption of innocence was so ironclad that no attempt to whittle it down could be entertained. In 2005, the House of Lords said that the underlying rationale for the presumption of innocence was that to place a burden on a defendant was repugnant to ordinary notions of fairness. The presumption of innocence is also affirmed under international law, in the Universal Declaration of Human Rights. The United Nations Human Rights Committee stated that the presumption of innocence imposes a burden on the prosecution of proving the charge and guarantees that no guilt can be presumed until the charge has been proved beyond reasonable doubt. Now, the case of Wilmington, that case that etched the principle of the presumption of innocence irreversibly in stone, is such an important case that I believe I should go into some details in the facts of this case. Reginald Wilmington was a 21-year-old farmer. At the time, he was married to a 17-year-old woman by the name of Violet. And she gave birth to their child in October of 1934. Shortly after the birth, the couple had a falling out. On the 22nd of November 1934, the wife Violet left the matrimonial home and went to live with her mother. On the 10th of December 1934, Wilmington stole a double-barrel shotgun from his employer and went to his mother-in-law's house. There he shot and killed his wife. He was arrested on the 23rd of January 1935 and charged with the offence of murder. Wilmington's defense was that he did not intend to kill, and thus he lacked the necessary mens rea. Specifically, he claimed that he had wanted to win his wife back and planned to scare her by threatening to kill himself, and if she refused, then he would shot himself. He attempted, he said, to show her the gun, which he discharged accidentally, killing her instantly. At the Bristol Assizes, where he was tried, Wilmington was found guilty. The judge ruled that the case was so strong against him that the burden of proof was on him to show that the shooting was accidental. The jury deliberated for just a mere 69 minutes, and on February 14, 1935, Wilmington was convicted and sentenced to death. He appealed to the Court of Appeal. His defense team argued that the judge had misdirected the jury. Leave to appeal was refused, reliance being placed on a passage of Forster's Crown Law of 1762, which placed the burden of proof on a defendant in a murder charge. Subsequently, the Attorney General granted Wilmington a fiat to proceed an appeal to the House of Lords. Delivering the judgment for a unanimous court, Viscount Sankey made his now famous and memorable golden chair speech. And from this judgment, I quote liberally. Viscount Sankey said, throughout the web of the English criminal law, one golden thread is always to be seen, that it is the duty of the prosecution to prove the prisoner's guilt, subject to the defense of insanity, and subject also to statutory exceptions. If at the end of the whole case there is a reasonable doubt created by the evidence given either by the prosecution or the prisoner, the prosecution has not made out the case, and the prisoner is entitled to be acquitted. No matter what the charge or where the trial, the principle that the prosecution must prove the guilt of the prisoner is part of the common law of England, and no attempt to whittle it down can be entertained. End of quote. The conviction was quashed, and Wilmington was acquitted. He was released 3 days before his scheduled execution, still aged 21. Now, Lord Sankey, in the case of Wilmington, had expressed that there are exceptions to the presumption of innocence. He specifically spoke about statutory exception and the defense of insanity. And those two categories, Lord Sankey seems to indicate that the legal burden may shift from the prosecution to the defendant. However, the legal burden placed on the defendant is the same as a legal burden in a civil case. It is one of the balance of probability instead of being reasonable doubt, which is the burden placed on the prosecution. The first major case brought in the UK and the issue of reverse burden under the Human Rights Act of 1998 was the case of R and Director of Public Prosecutions, ex parte, Kilbilin. This case was brought in 2000. Lord Hope, in Ubita comments, addressed the issue of conflict between the reversal of legal burden and the presumption of innocence under Article 6.2 of the European Convention on Human Rights. The case of R. and Lambert in 2001, another landmark case in the UK House of Lords. The court discussed the impact of the Human Rights Act and statutory provision of reversal of the legal burden. The court held that the first step was to establish whether the reversal was an infringement of the presumption of innocence. Their lordships agreed that the effect of the provision at that time was to impose a legal persuasive burden which infringed on the principle of presumption of innocence. The next step, according to their lordship, was to consider whether this infringement was objectively justified and proportionate so that the legislative means adopted were not greater than necessary. And the final step was to assess whether it was possible to read Section 28 of the Misuse of Drugs Act 1971, which placed the reverse burden on a defendant in a way that was compatible with convention rights. If it is not compatible with convention rights, a reading down of the legislation is required to prevent wrongful conviction in light of Article 6.2 of the European Convention on Human Rights. The approach in R. and Lambert was subsequently adopted in a later court case in the Court of Appeal, the case of R. and Karras in 2001. As earlier stated, in order not to infringe on the presumption of innocence, the court held that where statute impose a legal persuasive burden of proof on a defendant, the standard of proof is on a balance of probability and not beyond reasonable doubt. A defendant could discharge this burden through cross-examination or by calling other witnesses without himself having to give evidence, thus preserving another important legal principle, the right to silence. And I will speak about the right to silence in another episode. In the United Kingdom, although a suspect is not compelled to answer questions after formal arrest, failure to give information he or she intends to rely on at a trial may be prejudicial to his defense. In the Turks and Caicos Islands, there is no such requirement. Therefore, a person arrested by the police has a constitutional right to silence. This right is absolute. Thus, it protects the person against self-incrimination. Notwithstanding statutory changes encroaching on the principle of the presumption of innocence, including absolute offences and strict liability offences, which I will deal with in another episode, most legal scholars are confident that the principle of presumption of innocence remains intact and essential to criminal proceedings. In the next episode, I will deal with the right to silence and the burden of proof in criminal cases. Thank you for watching.